Today, I'd like to tell you about the Article 3 of Section 1 and Section 2. Let's start first with Section 1, Due Process of Law. Due process is a legal maxim which hears before it condemns and renders judgment only after trial. Due process of law generally requires that, first, there must be a court with judicial power to hear and decide the matter before it. Second, the respondent must be given an opportunity to be heard. Third, the court must acquire lawful jurisdiction over the person or the accused over the property which is the subject of the proceedings. Fourth, judgment must be rendered following the trial. Due process does not necessarily require a hearing, but simply an opportunity to be heard. There are three classifications of due process of law, namely procedural, substantial, and administrative due process of law. First, procedural due process is the fairness of the procedures used to enforce the law. It focuses on fair and timely procedures. It is far less complicated and controversial than substantive, which focuses on government regulation of conduct, such as abortion, sexual conduct, and certain family matters. Second, substantive due process. This refers to the law itself, to the application of the appropriate law in certain case. Law must be fair, just, and reasonable. Third, administrative due process. The Angtibay case provides requisites for administrative due process. First, right to a hearing. Second, the tribunal must consider the evidence forwarded or adduced. Third, the tribunal must support the decision made. Fourth, the decision must be culled from the evidence presented by both parties. Fifth, the decision of the case must be arrived at by an independent tribunal. And the last, the tribunal should in all controversial questions render its decision in such a manner that parties can know the various issues involved and the reason for the decision. The standard due process in student grievance case. First, the students must be informed in writing of the nature and cause of an accusation against them. Second, they shall have the right to answer the charges against them with the assistance of counsel if desired. Third, they shall be informed of the evidence against them. Fourth, they shall have the right to adduce evidence in their own behalf. And the last, the evidence must be duly considered by the investigating committee or official designated by the school authorities to hear and decide the case. Person, life, liberty, and property. A natural person is a human being of whatever sex or age, possessing physical attributes of a rational being. Common crime against persons includes homicide, murder, and parricide. Parricide is any person who shall kill his father, mother, or child, whether legitimate or illegitimate, or any of his descendants, or his spouse shall be guilty of parricide and shall be punished by the penalty of reclusion perpetua to death. Life. The term life is attributed to the physical appearance and existence of a human form. Deprivation of life includes the loss of any of the various physical and mental attributes which man must have to live with as a human being. Liberty. The term liberty means not only the right of an individual to be free from physical restraints of his person, such as by imprisonment or detention, but also the right to be free in the use of his faculties in all lawful ways. Example, freedom of expressions, speech, and travel. Deprivation of liberty means the prevention, suppression, and restriction of human freedom and expression. A person may be deprived of his liberty when he uses it unlawfully or abusively by committing acts amounting to crime. Slavery is one of the crimes against liberty. Slavery is anyone who shall purchase, sell, kidnap, or the penalty of prison mayor and a fine of not exceeding 10,000 pesos shall be imposed upon anyone who shall purchase, sell, kidnap, or detain a human being for the purpose of enslaving him. Property. Property may refer to a thing itself or the right over the thing. It includes the right to own, use, transmit, and even destroy the property. Deprivation of property exists when the property is unlawfully confiscated or when the exercise of the right over a property is unreasonably prevented. Robbery, brigandage, theft, stapa, malicious theft, arson are examples of crimes against property. Did you know on May 29, 2015, a month after 32 closed-circuit television CCTV cameras who were installed at Pasig Rotonda, Interior Secretary Manuel Rojas II, reported that weekly theft and robbery cases in the area went down from 50 to 3 to 10 cases, an 80 to 94% decrease. Theft robbery cases dropped by 94% after CCTV cams installed. Equal protection of law. All persons or things similarly situated should be treated alike both as to rights conferred and responsibilities imposed. Section 2. Search warrant and warrant of arrest. This section provides for rights against unreasonable search, seizure, and arrest. The coverage of the protection for unreasonable search and seizure are the persons, their houses, papers, and effects. The term person includes all persons without regard to any distinctions as to race, color, or status. Search warrant. Search warrant is a legal document authorizing a police officer or other official to enter and search premises. A warrant of arrest is a command in formal writing issued against a person to take him into custody of law in order that he may be bound to answer for the commission of an offense. For a search warrant to be enforcing, that is with legal and binding effects, the following conditions and reasons must be observed accordingly. First, it must be issued upon probable cause. Second, the probable cause must be determined personally by a competent judge. Third, the existence of a probable cause is determined on the basis of careful examination by a competent judge. And the last, the warrant must specifically identify and describe the place to be searched or the person or things to seize. Probable cause is facts or evidence that would lead a reasonable person to believe that a suspect has committed a crime. In contrary to prima facie evidence, it is based on evidence of facts so relevant and so strong that it would be hard to dispute or refute. For example, a fingerprint or DNA analysis result pointing to the identity of a suspect is a factual basis constituting a prima facie evidence. Determination of probable cause in search warrant and warrant of arrest. In search warrant, the judge must personally examine in the form of searching questions and answers, in writing and under oath. In warrant of arrest, the judge would simply and personally review the initial determination of the prosecutor to see if it is supported by substantial evidence. Circumstances for warrantless arrest. First, when the person to be arrested is in flagrante delicto, caught in the act, or is attempting to commit an act constituting a felony. Second, when the right has been voluntarily waived, such as posting of bail bond or when there exists consent. Third, when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or temporarily confined while his case is pending or has escaped while being transferred from one confinement to another. Thank you for listening. That's all. Thank you.
Created using Powtoon.